If you have a must-come green card, a South Bide, you could be just one mistake away from losing your permanent residency. And most people don't even know it. From long trips abroad to criminal records, tax problems, and even checking the wrong box, these my 10 ways to lose your green card can put you into deportation and removal proceedings. Fast. If you have a green card, you could be just one mistake away from losing your permanent residency. And most people don't even know it. From long trips abroad to criminal records, tax problems, and even accidentally checking the wrong box on a form, there are several ways to put your green card and your future in the United States at risk much faster than you think. You're watching Immigration Updates Hub, where we explain U.S. immigration rules in calm, clear language so you don't have to learn them the hard way at the airport or in an immigration courtroom. Let's talk about how green card holders actually lose their status in real life and what you can do to avoid these traps. One of the most common ways people lose their green card is by staying outside the United States too long. As a lawful permanent resident, you are allowed to travel. You can visit family, spend extended time abroad, or even work outside the U.S. for certain periods. But there is a line that, if crossed, can be used as evidence that you've abandoned your residency. A simple rule of thumb is this: if each trip you take outside the U.S. is less than 6 months, you are generally in a much safer zone. The moment any single trip goes over 6 months, more than 180 days, you should expect more questions when you return. At the airport or land border, Customs and Border Protection officers can ask why you were gone so long, whether you are still living and working in the United States, whether you were working while abroad, and where your true home is. They can also review your record, including any criminal history, more closely. If you stay outside the U.S. for more than 1 year without having a valid reentry permit, things become even riskier. In many cases, immigration can treat that long absence as abandonment of your green card. Even if none of your trips individually crosses the 6-month mark, a pattern of repeated long trips can still make it look like your real life is based outside the United States and that you only come here now and then. Remember, the purpose of permanent residency is not just to have permission to enter the United States. It is to live here with the intent that this is your primary home. Today, the U.S. government uses entry-exit records and biometrics to track movements much more closely than in the past. Every time you enter or leave the U.S., that information is logged and attached to your immigration record. Patterns of long stays abroad are easy to see. To protect yourself, try to spend at least 9 to 10 months out of every year physically present in the United States. If you think you may be outside the U.S. for 6 months or more on a single trip, apply for a reentry permit before you leave. A reentry permit doesn't guarantee reentry, but it strongly supports your claim that you did not intend to abandon your permanent residence, and it can make the process at the border much smoother. The second way people put their green card at risk is by failing to maintain strong ties to the United States. Some think that as long as no single trip lasts longer than 6 months, they are automatically safe. That's not exactly how immigration looks at it. Officers care about where your everyday life is based, not just how many days you were gone. Strong ties include having a genuine fixed address in the U.S., a lease, a mortgage, or living with close family where you actually keep your belongings and receive your mail. Financial ties are also important. Having U.S. bank accounts with regular transactions, using U.S. credit cards, and filing U.S. tax returns every single year as a resident. Work or business ties matter. A job with a U.S. employer, running a U.S. business, or staying on a U.S. payroll. Family ties are powerful. Having a spouse, children, or other close relatives living in the United States. If you have school-aged children, keeping them enrolled in U.S. schools is one of the strongest pieces of evidence that your home is here. Community ties help as well. A driver's license or state ID, memberships, religious attendance, and other activities that show your social and community life are centered in the U.S. If too many of these are missing, immigration officers can reasonably question whether you truly live in the United States. Even if none of your trips abroad are very long, a life that appears to be mostly overseas with only short visits to the U.S. can still look like abandonment of permanent residence. Before you take extended trips, it's wise to step back and ask, if an officer looked at my address, taxes, job, bank accounts, family, and daily routine, would it be clear that my real life is in the United States? The third major way to lose a green card is through certain criminal convictions. Immigration law does not treat all legal problems the same. Minor traffic infractions like parking tickets or small speeding tickets are not going to get you deported. But more serious offenses, particularly those involving dishonesty, harm, or controlled substances, can be very dangerous for your status, even if the criminal court treats them as relatively minor. Some offenses fall into a category called crimes involving moral turpitude. This usually means crimes that show bad intent or dishonesty, such as theft, shoplifting, certain types of fraud, some domestic violence cases, and some types of assault. Under immigration law, a single crime in this category, committed within 5 years of being admitted as a permanent resident and carrying a maximum possible sentence of 1 year or more, can make you deportable. The key is what the maximum wanted possible penalty could have been, not just what you were actually given. If you have 2 or more such offenses at any time, even many years apart, that can also make you removable. Then there are aggravated felonies under immigration law. This category covers some of the most serious violent and drug-related crimes. If you are a green card holder and you are convicted of an offense classified as an aggravated felony, removal from the United States becomes extremely likely. These cases almost always lead to mandatory immigration detention, and in most situations there are no waivers or meaningful forms of relief available. Even driving under the influence, or DUI, has become more serious in immigration terms. A single incident can delay or complicate a future citizenship application. Multiple incidents can lead to a citizenship denial under the good moral character rules. There have even been legislative proposals to treat certain alcohol-related driving offenses as specifically deportable for non-citizens, which shows how seriously these cases are viewed. A critical point that many people miss is that immigration law has its own definition of conviction. For immigration purposes, a conviction can include pleading guilty, pleading no contest, certain diversion programs, probation, suspended sentences, or time served. Even cases that are later expunged or dismissed can still appear on background checks and trigger further review. If you are a green card holder and you are arrested or charged with any crime, do not accept a plea or sign anything final without speaking to an immigration-savvy attorney. Many criminal defense lawyers are excellent at criminal law but may not understand the immigration consequences of certain pleas. One decision in criminal court can quietly and permanently damage your immigration status. The fourth way to risk losing your green card is through serious tax problems. Immigration agencies, especially when reviewing citizenship applications, but also other filings, look much more closely now at whether permanent residents are complying with U.S. tax laws. As a lawful permanent resident, you are generally required to file a U.S. tax return every year and to report your worldwide income, even if you live or earn abroad part of the time. If you fail to file tax returns that you're required to file, if you file as a non-resident to avoid certain obligations while holding a green card, or if you build up large unpaid tax debts and ignore IRS notices, this can be used against you. It can suggest that you don't consider the U.S. your real home. It can create good moral character concerns which are important for naturalization and can also affect how USCIS views you in other contexts. In more serious situations, deliberate tax evasion involving substantial amounts can be treated very harshly under immigration law and can even be used as a basis for removal. The good news is that you can address tax problems proactively. If you've missed years, work with a tax professional to file back returns, ideally before filing any new immigration application. If you owe money to the IRS, contact them to set up a payment plan and stay current on those payments. Keep copies of your returns and IRS transcripts. Often, the first thing an immigration officer will do if they have tax-related questions is look for those transcripts. U.S. immigration is not demanding perfection in your finances, but they expect honest effort and responsibility. The fifth way green card holders lose their status is by making a false claim to U.S. citizenship. This is one of the most dangerous mistakes you can make as a non-citizen. It sounds extreme, but it often happens in everyday situations where someone checks the wrong box or misunderstands a question. A false claim to citizenship can happen when you check U.S. citizen on the Form I-9 when starting a new job, when you register to vote or actually vote, when you apply for federal student aid as if you were a citizen, when you try to apply for a U.S. passport without being a citizen, when you claim to be a citizen to receive certain public benefits, or when you use someone else's U.S. passport or birth certificate. Under current law, a false claim to U.S. citizenship can have extremely serious consequences, including being placed into removal proceedings, losing your green card, being permanently barred from many immigration benefits, and even facing criminal charges. In many cases, there is no waiver available. What makes this especially dangerous is that immigration law does not always excuse these claims based on confusion or pressure. In many situations, even if you did not fully understand what you were doing, the claim can still count. The safest approach is simple. Whenever you see a question that asks if you are a U.S. citizen, on job forms, government forms, school forms, voter registration, slow down. If you are not absolutely sure, do not mark yourself as a U.S. citizen. Ask questions or get legal guidance first. One wrong checkmark can create a permanent problem. The sixth risk applies mainly to people with a 2-year conditional green card based on marriage. A conditional green card cannot be renewed like a standard 10-year card. Instead, you must file a petition to remove the conditions, usually Form I-751 for marriage-based cases, during a specific 90-day window before the card expires. If you miss that window and do not qualify for a late filing waiver, USCIS can treat you as being out of status and may move to terminate your residency and send your case to immigration court. Late filing can sometimes be excused if you show good cause and extenuating circumstances, such as serious illness, being outside the U.S. and unable to return, incorrect legal advice, abuse or extreme cruelty, or divorce and other complications. But if you do nothing, let the card expire, and never file an I-751, immigration will likely treat your residency as abandoned. If your marriage is in trouble or you're divorced or in an abusive situation, you may still have options to file I-751 alone with a waiver. But you must be proactive. The worst thing you can do is ignore the expiration date and hope it does not matter. Another major way people lose their green card is when immigration concludes that the underlying marriage was not real. Marriage fraud is seen as a direct attack on the integrity of the immigration system. If USCIS or ICE comes to believe your marriage was entered into mainly for immigration papers and not as a genuine relationship, they can deny your petitions, revoke your existing status, place you in removal proceedings, and impose long-term or even permanent bars to many future immigration benefits. This does not only affect people who intentionally entered fake marriages. Real couples can end up under intense suspicion if there are many red flags in their applications and interviews. No shared finances, no shared residence, conflicting answers on basic questions, or a lack of evidence of a shared life. USCIS looks closely for patterns like paid marriages, marriages as favors, mail order arrangements with no real contact, or couples who never really lived together. Even if you already have a 10-year green card, if convincing evidence later emerges that the marriage was not genuine, your status can still be challenged years later. If your marriage is real, your best protection is to keep thorough and consistent evidence. Joint bank accounts, leases, mortgages, utility bills, insurance policies, photos over time, messages, travel records, and anything else that shows a real shared life. Answer all questions honestly, and don't ignore USCIS notices. If your spouse refuses to participate or seems to be sabotaging your case, get legal help as soon as possible. That dynamic can become a serious threat to your status, if not handled correctly. Another big problem area is misrepresentation, deliberately providing false, incomplete, or misleading information to obtain an immigration benefit. This doesn't just mean huge, obvious lies. It also includes leaving out important information or shaping answers in a way that hides crucial facts. Examples include concealing a prior deportation or removal order, failing to mention prior visa overstays or immigration violations, hiding previous marriages or children, using an incorrect A number to avoid linking to older files, or submitting documents that contradict earlier applications without a good explanation. For misrepresentation to be found, immigration usually needs to believe that you knowingly gave false or misleading information and that the information was material, meaning it influenced the decision. If they conclude both are true, they can revoke a green card, even years after it was issued. Modern data systems let DHS compare your past and current forms, look up travel, tax, and identity records, and find inconsistencies very quickly. Honest mistakes are not the same as misrepresentation, but if a mistake looks intentional and significant, It can be extremely hard to fix, and waivers are very limited. The best way to protect yourself is to be as consistent as possible across all your filings and to talk with an immigration attorney before trying to fix old errors on your own. The way you correct a past mistake matters a lot. Then there's something that seems very small but matters legally: not updating your address with USCIS. U.S. law requires most non-citizens, including green card holders, to notify USCIS within 10 days of moving to a new address. This is done using Form AR-11. Updating your address with the post office or your employer does not update it with USCIS. If you don't update your address, USCIS could send important mail, like appointment notices, requests for evidence, or decisions, to your old address. You might miss a biometrics appointment, an interview, or even a hearing. Missing these because you didn't keep your address updated can be used against you as a sign you are not complying with immigration requirements. Today, you can file AR-11 online quickly and easily. The key is to do it every time you move and to save confirmation that you did so. Finally, you can lose your green card by voluntarily giving it up. This is called Abandonment of Residency and usually happens when someone signs Form I-407, which formally tells the U.S. government they no longer wish to be a lawful permanent resident. Once Form I-407 is accepted, your green card is gone. There is no appeal and no automatic way to get it back. From that point on, for U.S. immigration purposes, you are treated like any other foreign national. You may need a visa just to visit the United States. If you ever want a green card again, you must start the process from the beginning. Any spouse or children who received their green cards through your status may also be affected. People abandon their green cards for many reasons: moving abroad and not planning to return, wanting to simplify their tax situation, preferring to visit the U.S. as a tourist rather than live here, or feeling that their work and life are now permanently based somewhere else. Whatever the reason, you should only take this step if you are absolutely sure you no longer want to live in the U.S. as a permanent resident, and you fully understand how difficult it can be to obtain residency again in the future. So, in summary, green card holders lose their status most often by staying outside the U.S. too long, failing to maintain real ties to the United States, being convicted of certain crimes, having serious tax problems or financial misconduct, making false claims to U.S. citizenship, missing the deadline to remove conditions on a 2-year card, having immigration conclude a marriage was not genuine, committing misrepresentation in immigration filings, failing to update their address with USCIS, or voluntarily abandoning residency. If you are a permanent resident and you eventually want to become a U.S. citizen, protecting your green card now is protecting your future path to citizenship as well. If this explanation from Immigration Updates Hub helped you see these risks more clearly and gave you practical ideas to avoid them, that's exactly what it was meant to do. You worked hard to get your green card. You deserve to keep it and to understand how to keep it safe. Stay informed, stay careful, and always think one step ahead. If you have a green card, you could be just one mistake away from losing your permanent residency. And most people don't even know it. From long trips abroad to criminal records, tax problems, and even checking the wrong box, these Kiban and 10 ways to lose your green card, Dani, can put you into deportation and removal proceedings. Fast.